questions or comments as they occur to you during the lecture. And so it is with great pleasure that I present our speaker today, Professor Angela Fernandez, a truly innovative interdisciplinary scholar of animal law, legal history, and property law. She is currently a professor at the Faculty of Law at the University of Toronto, where she also has cross-appointment with the Department of History. With degrees from McGill, Yale, and Queen's University, her research has focused on a particular style of legal history called legal archaeology, including a book-length study on an infamous first possession property case involving a fox, Pearson versus Post, The Hunt for the Fox, Law and Professionalization in American Legal Culture, which was published by Cambridge University Press in 2018. It's a groundbreaking book, and I recommend it highly. Professor Fernandez's work has been recognized worldwide, and she contributes to many organizations, including as a member of the Brooks Animal Studies Academic Network, as a director of Animal Justice Canada, as a fellow of the Oxford Center for Animal Ethics, and as an associate editor of book reviews for the Americas with the Law and History Review. Most recently, Professor Fernandez has worked with the Brooks Institute and University of Toronto to launch the Canadian Animal Law Digest, which will be available any day, I think, so keep your eyes out for this important resource. More information about her work, including her inaugural lecture for the series Animal Law Fundamentals, will be posted in the chat. Today, Professor Fernandez will share her thoughts on the possibility of rejecting the binary person-property distinction that has hijacked animal law scholarship, and she will provide her insights into alternative ways forward for animals and their advocates. Without further ado, thank you for being here, and please join me in welcoming Professor Fernandez.
Thanks so much, Becca, for that nice introduction. I want in this talk to lay out the argument for the quasi-hood approach, what I call the quasi-hood approach to the legal status for non-human animals. Given that this talk is affiliated with the CEAP, the Center for Environmental and Animal Protection, and housed in the Department of Environmental Studies, I'd like to emphasize the wider frame of reference for thinking about non-human beings in terms of environmental entities, and I'll do that more towards the end of the lecture. As Becca mentioned, there's a larger paper and video, which is available at the Brooks website, Brooks U Fundamentals of Animal Law, which is a series that launched just last week. I'd like to take this opportunity to thank Brooks for supporting that work and also for supporting this virtual lecture today, and to thank my hosts for having me. I'll start with some words about where this project is coming from. As Becca mentioned, I'm a law professor and a legal historian who really fell into animal law sideways due to extensive legal archaeological work on the famous property law case Becca mentioned about a hunted and killed fox, Pearson versus Post. I mapped out in that book the professionalization or hijacking of the case by the judges and lawyers that were involved in it in 1802, and sort of every successive generation of legal scholar and academic since. I started feeling as I was excavating this history quite bad about doing a version of what I was outlining that had always been done with this case in terms of uber professionalizing it or hijacking it again in yet a different way, even if I was building in some awareness of the animal's plight and resources for critiquing its treatment as property. So really, how I see my animal law work is really, in a sense, a kind of working off of a debt, as it were, that I feel I incurred in terms of that work in that book. One of the things I did in preparation for this lecture was to read, actually for the first time, Isaiah Berlin's famous essay, The Hedgehog and the Fox, an essay on Tolstoy's view of history. And why did I do that? Well, first of all, because I've always wanted to read it. And so I felt like I had an excuse to legitimately carve out time to do this. But secondly, also because I thought at this talk, or maybe some future talk, I think someone is going to ask me the question about foxes and hedgehogs and whether I'm one or another. Okay, and obviously because of the Pearson work being about a fox, but also this quasi approach I'm talking to you about today is really like a one big idea thing. And as many of you know, this fox and hedgehog idea is that the fox knows many things. It has many tricks, as it were, whereas the hedgehog only knows one thing. It only knows how to do one thing, which is roll up in a ball to avoid getting hurt. In the original Greek poem, apparently, I just learned this very recently doing research about this, the hedgehog was female. And in the poem, she's using her one trick to ward off unwarranted or unwanted romantic sexual advances by the fox, who's trying to use every trick in the book to woo her. So there's this interesting gender aspect to it that I didn't know about. Michael Ignatieff, Berlin's biographer, explained that the title and the essay for the book came from this particular parlor trick that Berlin liked to play. Which writers were foxes, which writers were hedgehogs? And as many of you will probably be familiar, it's been brought into popular culture as standing for this idea that there are two different kinds of people. There's foxes and there's hedgehogs. And on a more deeply philosophical iteration of this, there's also the sense that there's two different ways of viewing reality. And there is this sense that foxes generally are supposed to be kind of happier people. Why? Because they're at peace with only ever knowing many things, whereas hedgehogs are doomed to be tortured by their one big idea. They see it that it's imperfect. They see that it fails in various contexts. They can't unify everything. They can't reconcile everything. They intermittently realize that it's an illusion. And so they are more of the unhappy animal in the duo. If you know this essay, you'll recall that Berlin thought Tolstoy was a fox by nature, describing life in his masterpiece, War and Peace, in all its wonderful quotidian detail, as only he could. But Tolstoy believed in being a hedgehog. He wanted to be a hedgehog, and in terms of reconciling or boiling everything down to one unifying principle. So I'll just read to you a little bit from the text, just because it's so wonderfully written. Berlin writes, Tolstoy's genius lay in the perception of specific properties, the almost inexpressible individual quality in virtue of which the given object is uniquely different from all others. Nevertheless, he longed for a universal explanatory principle, that is, the perception of resemblances or common origins or single purpose, or unity in the apparent variety of the mutually exclusive bits and pieces which compose the furniture of the world. As for foxes and hedgehogs, Tolstoy perceived reality in its multiplicity as a collection of separate entities round and into which he saw with a clarity and penetration scarcely ever equaled, but he believed only in one vast unitary whole. No author who has ever lived has shown such powers of insight into the variety of life, the differences, the contrasts, the collisions of persons and things and situations, each apprehended in its absolute uniqueness and conveyed with a degree of directness and a precision of concrete imagery to be found in no other writer. No one has ever excelled Tolstoy in expressing the specific flavor, the exact quality of a feeling, the inner and outer texture of the feel of something, set in an absolutely specific context in time and space, an event fully present to the senses or the imagination in all its facets, with every nuance sharply and firmly articulated. Yet, what he believed in was the opposite. He advocated a single embracing vision. He preached not variety, but simplicity, not many levels of consciousness, but reduction to some single level. In War and Peace, to the standard of the good man, the spontaneous open soul, the peasant or the simple Christian ethic, and so on. This belief then in the one simple thing, according to Berlin, made Tolstoy skeptical about history. And indeed, the essay, when it was first published, was called Tolstoy's Historical Skepticism. Berlin himself noted when Ignatieff asked him about this, that no one ever read it when it had been published under that title. And it wasn't until he gave it the catchy fox hedgehog that anyone paid any attention, which for us is an important lesson just in terms of like the importance of titles. But there also is this truism that has kind of comes from this, which is that, you know, everyone probably is combining both being a fox and being a hedgehog, although in different proportions and in different interactions. The Pearson work, of course, is very foxy. It's a variety of details, more detail probably than you could ever want about this particular case and all of its facts and circumstances. The quasi idea, on the other hand, is very hedgehog. And so I'm cognizant of this sort of sitting together in a slightly uncomfortable way, not reconciled, But I think that's okay because the quasi proposal is this one big idea, but it's coming from a very practical or pragmatic space or place rather than a theoretical place or a very firm theoretical commitment. What is that practical pragmatic space? Well, it's the sense I have coming to the field of animal law that there is a very particular way in which the field has become stuck or trapped. And this has happened, I think, in at least two specific ways. In terms of the property personhood paradigm, first of all, and second of all, also in terms of the rights welfare paradigm. And I think it's fruitful to try to think of some ways out of this. An earlier speaker in this workshop series, a colleague of mine, a fellow Canadian animal law scholar, Mani Shideka, spoke to you earlier this year in February about how her concept of being is one way out. So her idea is let's go for something completely different than either property or person. Quasi-hood is a different third way. It's not expressly abolitionist, and indeed it's compatible with, even if it's meant to challenge legal welfareism. The basic idea here is that the field of animal law in the last 25 years has made what I think might be a strategic error in terms of insisting that there are only two categories for non-human animals, either property or person, and that non-human animals must be moved from property to personhood in some way. That personhood being either moral personhood in the case of Gary Francione and his work, or legal personhood in the case of Steve Wise and the Non-Human Rights Project. Now, Steve Wise says he's asking for legal personhood in the formal sense of the vessel, empty vessel sense. But the approach that the group has taken is often about how the animals that they're choosing to represent are human-like. They're human enough like to be treated as persons, chimps or elephants. And so it doesn't really sound like it's just the vessel, empty shell notion of personhood. My feeling is that personhood in that style, because it's a bit confusing especially, is likely not going to work for common law legal systems, principally because it hits an outrage button that is closely tied in with human exceptionalism, speciesism, and dominant eating practices. So just to put it in a very basic way, if you're somebody who is eating meat or consuming animal products, it's going to be very hard for you to accept any animal as person, because then you have to reconcile yourself with basically being a cannibal, and that's a lot to ask people to take on and to break through on a psychological level. Now, if personhood is rejected, and all of this energy has been spent on insisting that there are only two categories, then judges, legislators, and members of the public will put non-human animals, I think, in the pure property category, which we probably all agree is a very bad place for them to be. So the idea here then is to try to describe the legal categories differently, so as to recognize that non-human animals do already have weak rights, or what Saskia Stuckey has called simple rights. These are welfare rights under animal welfare statutes. And so really non-human animals are already legal persons of a kind. Why? Because only a legal person can have any kind of right. Now, this is not full personhood by any means, and that's why I call it quasi-personhood. I think another good way to think of it is to think of it as a splintered personhood. And there are lots of historical examples of this, not laudable by any means, but if you think of Roman law slavery or married women, they have what's sometimes called an onerous form of personhood. And by that, by which is meant that there are incapacities. So for married women, for instance, it used to be that you couldn't make a contract or own property. There were disabilities associated with marriage. But there were things like you could still be liable for your own crimes, or you could issue a receipt, or you could be a guardian to a minor child. So there were some things that you could do. Now, married women were never property per se in the common law. Sometimes people say that, and that's, I think, not quite accurate, even if they were at risk of being treated like they were property because of these disabilities. But coverture, what happened when you got married, being made one person with the husband and having your legal identity swallowed up, that is something that didn't turn you into property, but it gave you a splintered form of personhood. And so that just shows that we do have the room kind of in our intellectual repertoire or our imagination to encompass forms of personhood that are like this, splintered or quasi. Now, quasi-personhood does not preclude or prevent non-human animals, were they to be given this categorization. It wouldn't preclude them from being considered property. So not things, provisions in statutes and civil codes all acknowledge non-human animal sentience, but they still keep animals as property. They say all property laws still apply. Yet, this must be a very special form of property that is sentient. And so what I am saying about this is that I think they could be referred to as property plus or quasi-property. Now, this is already legally recognized for companion animals. When they are hurt or killed, damages will or can extend beyond monetary value of the animal. In separation and divorce, similarly, you're not necessarily going to split the monetary value of the animal, which will probably be negligent or nothing. You can look at their best interest or their well-being. Property doesn't really have best interests or well-being. There can be trusts for pets. Again, not something that you would normally associate with pure property. Domestic violence protective orders can include animals, and also people can bring animals into shelters, which they can't do with other forms of property. So there's a sense in which we are already doing this, and it would be advantageous perhaps to have our language reflect that choice that we have really already made, actually. Now, this is not a binary either or, it's a both and, so it's quasi-personhood and quasi-property, so that's very important, that we're not just talking about one or the other. And to return to Berlin here, I'll just read you another passage shorter than the earlier one. And this is the editor, Henry Hardy, is just collecting at the end of the book things relating to this foxes and hedgehog thing. And he's got one passage here where he talks about Berlin loved categorizing. He loved categorizing individuals in the spirit of a party game. Most often there were two categories and two alone. Either you were, when it came right down to it, a conservative or a radical, shall we say, or you were either a hedgehog or a fox, or you were either a bishop or a bookmaker. He was inexhaustibly fertile in his two sorts of distinctions. It gave rise to a joke against him. The world is divided into two sorts of people: those who think the world is divided into two sorts of people and those who don't. And so we might say that looking at this proposal, you know, the world is kind of divided into two sorts of people: those who think non-human animals must be in one category or the other, property or person, and those who don't. And I'm obviously in the those who don't category, and I think it's a sort of a growing group to be in. That is maybe one way to see it. Now, the quasi-hood idea, it's no animal revolution. It's working with the categories that are already there, redescribing them. And in that sense, I think some people might find it limiting in that respect. But the idea is that the redescriptions can slide or move further away from property and or closer to personhood. And this is an advantage as over time as our conceptions about different animals change and grow. It's not an abolitionist perspective because property is still there. However, it isn't a welfare perspective either, really, because as per rights welfare, because the role here for rights is important, the simple rights, it's what gets the argument off the ground in the first place. The idea is this is good for common law lawyers because you're asking them to work with what they know rather than to adopt something that they're maybe unfamiliar with or don't really know what it is. Quasi is a known legal term, and like quasi-contract, for instance, and it connotes, I think, what's being described, a kind of a resembling, but not exactly the same as, an in-between space that lawyers will be comfortable with. And in fact, they might even like it because it's vague and they can work with it. I'll just read here a passage from the paper that Becca was talking about and posted in the chat. Here, I've just kind of collected some just like evidence about quasi and how it's used. So the OED, the Oxford English Dictionary, describes quasi as being prefixed to a noun, think property or person, with the sense resembling or simulating, but not really the same as. That properly so termed, having some of, but not all of the properties of a thing or substance, a kind of. Webster's puts it in terms of an as if, as it were, in a manner, in some degree or sense. Black's, which is important for common law lawyers, that law dictionary similarly defines quasi as an as if, almost as it were, analogous to, and it says that it's a term used to mark a resemblance and suppose a difference between two objects. Examples include, as I mentioned, quasi-contract, which is not quite a contract because it does not require promise. It's not based on intention, but it is enforceable insofar as the person who's been unjustly enriched by the transaction might be required to disgorge the advantage they obtained under it. Webster flags quasi as having a given legal status only by operation or construction of law without any intent, as in the case of a quasi-crime, or a quasi-trustee or quasi-right. There are many other quasi-legal concepts, such as quasi-admission, quasi-estoppel. Blacks list no less than 31 legal concepts that use the term, including quasi-corporation, quasi-delict, quasi-trustee, quasi-possession, quasi-usurer, quasi-easement. I could just go on and on here, and apparently I did. I didn't remember that I put quite so many. The National Labor Relations Board, a quasi-judicial body, the Interstate Commerce Commission, a quasi-legislative body. There's cases that recognize INS and AP, for instance, a famous property law case about the news, that there's a quasi-property in the news. We also have in Canada quasi-constitutional documents, human rights statutes, privacy and official languages legislation, other bills of rights statutes, and so on. And we typically say they have a quasi-constitutional status. So there is a lot of precedent there and familiarity and comfort, I think, in the common law. In a field where passions can run high, and it's good, I think, to have something that is at least relatively neutral. Nothing's totally neutral, but a term that's relatively neutral and that's descriptive in the way that quasi can be. It's not controversial. It's capable of being used widely as social notions and scientific understandings evolve and change. So I'm thinking here specifically of fish sentience, on which there is scientific consensus that fish suffer and feel pain, but that hasn't translated necessarily popularly with people. And they have not acknowledged that as much as they need to. Quasi can work well, I think, then for common law lawyers. But what about civil law lawyers? And I'm asking this question, and it's a bit of a strange audience to ask this question to, because there's probably not a lot of civil law people in the audience, civil law lawyers in the audience. But I was trained at McGill in the common law and the civil law. We were always told to kind of try to go back and forth. And part of it was that in doing that, you would understand, like, let's say if you were coming from a common law perspective, you would understand your own perspective better if you jumped over to the civil law and then sort of had to jump back again. It's kind of like travel, like you travel to learn better your own home context. Okay, so civil lawyers, what would they think about this? I think generally civilians wouldn't like it very much. I mean, I haven't done a survey on this, but I do think that they would maybe not be quite so keen, at least kind of pure civilian France kind of civil lawyers, because they tend to like to keep the categories quite separate. But that might be okay, because there are good reasons for thinking that personhood in civil law jurisdictions might be heard in a way that doesn't hit the outrage button in quite the same way as it does in common law jurisdictions. And why is that? Well, civil law lawyers are used to thinking about persons in a general abstract way. Why is that? Well, because civil law countries like France, Spain, Germany, Switzerland, Austria, Latin and South America, they have a civil code which sets out their private law. And the first book is a book on persons. It's based on the Gaian triad: persons, property or things, and actions. As I mentioned, I went to law school in Quebec, which is a mixed jurisdiction, common law and civil law, which probably explains in part why I like mixed things. And Quebec has a civil code, the first book of which has literally hundreds of provisions on the law of persons. And for common law lawyers, this is really weird. And they're like, well, why? What do you mean? What kinds of things? Well, there are rules in there about changing your name, changing your sex designation, changing your domicile or residence, respect of the body after death, consent to care, forced confinement for psychiatric reasons, declaring someone judicially dead, and then what do you do if they come back? Which, something maybe people have not ever thought about before, but this is a thing. Rights of minors, tutorship, which is a form of guardianship. There's also the register and acts of civil status. Acts of civil status are important moments in life, like birth, marriage, and death, and how those things are recorded. It's thickly populated for natural persons then, this book, or human beings. And then the book shifts to persons endowed with juridical personality. Now here, what's clearly contemplated, at least in the Quebec Code, is corporations. There's lots of the rules have to do with boards of directors and things like that. So they're thinking about corporations, but they're not actually using the word corporations, which is really interesting. And the whole idea is thought about then quite conceptually and abstractly in terms of an artificial juridical personality. In common law, we tend to hive this off. We'll call it, business law or corporations law, or University of Toronto, we call it biz-org, business organizations. But civil law really is sitting in this quite richly theoretical landscape, the law of persons. So you can pick up a treatise called that, or you can take a course, Quasi-Person, and it's a thing. It's a recognizable thing. So in a civil law, when you hear persons, you just think, oh, do you mean natural, human being, or do you mean artificial? In common law, it's a bit different. I think what people tend to hear more are disparate examples. So they hear, okay, corporations, ships, municipalities, the state, and none of them sound very analogous to each other or particularly to non-human animals either. And so there is a little bit of a disadvantage there, I think, in that respect. Now, this civilian idea of personhood being both natural and artificial might help explain why the habeas corpus approach that the Non-Human Rights Project takes has worked in Argentina with the orangutan named Sandra, and even to a greater extent, the chimpanzee Cecilia. Now, in Cecilia's case, the judge held that she was not just a movable object. Movable object is a chattel in civil law. She's not just a chattel, but she's part of the natural patrimony for which there is a constitutional right to protect and conserve, giving her a fundamental right to be born, live, grow, and die in an environment appropriate to her species. Countries like Ecuador and Bolivia, which have significant Amerindian Perspectivism, this is a term coined by a Brazilian anthropologist named Eduardo Viveiros de Castro. These countries with this perspective, they seem to have significantly less trouble seeing non-human animals as persons. It also makes them much easier to see rivers, lakes, trees, forests, and so on as having rights of nature. Kristen Stilt has written about this in the Harvard Law Review recently, arguing that this is promising for non-human animals because nature includes animals. So if you give nature rights, that's going to allow for the possibility of having rights-based claims made on behalf of animals. She gives the example of a Brazilian court using the constitutional protection for the right to an ecologically balanced environment, drawing on dignity from Germany and Switzerland, plus Ecuador and Bolivia's rights of nature. And this all work together to provide rights to free a wild captive parrot. Cecilia's case also drew on Gaia, the Greek goddess of Mother Earth, and Pachamama, the Andean goddess of Mother Earth, and indigenous thought to ground the right of Cecilia to a free and dignified life. It might be that people in the global South are able to hear the plight for animals about differently than those in the global North. Zoos, for example, are just very self-evidently colonial institutions, and I think often people in those countries can sort of see that a little bit more intuitively. Some of you may have heard the story of this hippopotamus, a very beloved hippopotamus in a zoo in El Salvador named Gustavito, who died in mysterious circumstances, and people thought that it might have been gang related. His death resulted in this outpouring of emotion. And a hashtag that was circulated was "Todos somos Gustavito." We are all Gustavito. So this idea that you can stand with a non-human animal is not so culturally hard to get your mind around. I'll share here in this respect a story that one of my students told me recently. So we've been trying at the University of Toronto to work on default veg, which is this sort of idea of using nudge economics that you kind of change the default from being animal product to being plant-based by just basically saying, if you want the animal, you have to ask for it, and then the default will be the plant-based. So it's quite an important and interesting movement. It's been a bit stalled here now because we're not really like eating anything at school right now because of COVID. So there's not a lot of progress being made. But one of my students, Rivers Wall, her name is, she was working for the Innocence Project last summer here at the University of Toronto, which is an organization for wrongfully imprisoned people. And she said that she brought the default veg idea to the group, none of whom were vegetarians or vegans, all of whom understood immediately what this was about, that they could see the connection between imprisoned people and imprisoned animals. And she said it took 5 minutes for them to decide, yeah, okay, we're going to do default veg. And so I think that's just to say that this empathy view, it's a view, it can be, you know, cultural to some extent also, but it's not possible for us to have it in our global North communities either. Okay, I wouldn't want to underestimate though the resistance that people have to these personhood, and there might be also to quasi-personhood. So for instance, I'll just recall here the first time I ever presented any animal work at my faculty. I was talking about Stephen Wise and his documentary Unlocking the Cage, and I was just basically explaining to people what it was about, and I wasn't even really advocating anything particular. And there was a judge who was visiting from Spain, and she really she just was like, no, I mean, animals operate on instinct. There's no voluntariness. There's no will here. And she didn't say we're supposed to be above them in the chain of being, but that's the feeling I really got. And so that's going to be there, okay, in countries, including civil law countries, and especially, you know, lots of them are Catholic, and so that's going to be there for sure. But there might be some, you know, some more wiggle room that we wouldn't necessarily appreciate. Now, the rights of nature outside of an Amerindian or indigenous perspective, I think is less triggering because these entities are so unlike humans. Also, I think people are becoming increasingly desperate to do something about climate change that they are feeling and they are seeing in their own backyards. So right now, for instance, in Canada, we're just coming out of these terrible floods on the West Coast in British Columbia. In the last 2 weeks, and then now in the last 4 months, we've learned about atmospheric rivers that have killed now thousands of farm animals, have died, drowned, or hypothermia. And there's been human deaths as well. Over the summer, there was the heat dome, which boiled alive 1 billion aquatic animals on that coast and killed about 500 elderly people who didn't have air conditioning. So, you know, these are situations that are really like on us, and we are in it right now. And people, I think, are more inclined to turn to whatever legal mechanisms they might have available to them. In Canada, we also have the example of the Magpie River in Quebec being given a personhood standing. It runs through Cree territory. So you've got a kind of combination, I think, in that case of the Indigenous perspective, but also civil law personhood being understood in abstract terms. So I think the Magpie River could be used helpfully that way. I don't want to overgeneralize, but it's very possible that personhood sounds or lands differently depending on the presence or absence of an Indigenous perspective or a civil law abstract framework. So if they don't like quasi, in other words, I think it's maybe okay. But the global North and common law, to me, feels like the recalcitrant kind of, you know, like sibling in this dynamic. Okay, and this proposal is really offered for that audience, okay, as a way to chip away at this, while many people become closer to thinking, okay, some form of personhood might be palatable, pure property is not accurate and is not acceptable, and it's actually no longer really what we think anyway, as you know, if we've accepted sentience. Although it is possible that a civil law jurisdiction might go for it, especially a mixed one like Quebec, which mixes a lot of things. But that's really not the audience. The audience is really more for common law people. And indeed, we might say that corporations themselves should be thought of as quasi-persons. And this is not something that is usually talked about. Why? Well, because when personhood was adopted for corporations, it was just sort of done because it was so convenient. It was such a good idea, right, to have a veil between the individual and the assets, and to limit liability and so on. So people didn't really feel the need to theorize it all that much. But if you think about it, in a way, they are kind of quasi-persons only. Why? Because there's some things they can do, some rights they have to own property, enter into contracts, sue and be sued, but they can't vote, they can't get married, and even if they do have free speech and some rights to religion in the US. Okay, corporations, what about children? Children have some but not all rights. But I think children are, because they're human beings, they're going to be in the natural category of persons. And so that's where they would go. And then the artificial category is left open for the non-human beings. Possibly corporations could be put in there, non-human animals, rivers, lakes, and people might be okay with giving them that form of personhood with some rights. And then they can increase those rights and become better over time, and certainly better than what they currently have. There's a discomfort with non-human animals and personhood. So quasi-personhood, quasi-property is a concession, hopefully a temporary concession to that discomfort. I've called it elsewhere a temporary heuristic. And why is it temporary? Well, I think because this is an inherently unstable situation that we have on our hands right now, with entities having some rights. So they're not objects, but they remain property in an augmented way, though, due to their sentience. This is very unsustainable. Although we do know that people can tolerate the unsustainable if they have good reasons for doing that. But it's important, I think, to just kind of call it out and say it is really quite a contradiction. To return to the hedgehog and the fox, it's okay for the one big idea then, in my mind, to be thin and abstract and unreconciled with the myriads animals, species, and remarkable individuals even, because it's not meant to be reconciled. In a sense, then, it's the opposite of Decca's being, which is very thick with relational content. It's also different than the kind of personhood I think many animal advocates want, or some animal advocates want at least, because they want it to capture what's special and worth protecting or preserving about non-human animals. So this quasi-proposal is really the opposite, actually, of that. It's definitely the empty vessel sense of personhood, and I want it to be clear that it is, so that it can be wide and applied to a wide variety of species, not just the human-like ones, chimps, other primates, elephants, and cetaceans. Decca and others like Tammy Bryant have argued convincingly that this is bad for non-human animals, to force them to meet human benchmarks, deny their animality, and then only the most humanized animals are going to make it in. So the quasi-concept, in other words, is intentionally thin. Manisha, Jess Eisen, and I debated with Gary Francione and Stephen Wise at the keynote roundtable of the Canadian Animal Law Conference in October. It's a very fun event. And we talked about the property personhood paradigm. A question came from the audience asking about motivation. This came from Jesse Schwartz, I believe, although I haven't actually rewatched to make sure that it is Jesse, because I can't rewatch any video that so I won't be rewatching this one either, because my view is it's a river, it's a flow, it's flowed past you, that's good. Anyway, Jesse, if it wasn't you, I apologize, but I think it was Jesse who said, like Quasi is not very inspirational. And I will concede that, actually. And I think that's okay, and that it's not necessarily inspirational or in any specific way inspirational. Why? Because it doesn't have specificity to it at all, actually. And I think that's a virtue, that it's not foxy at all. It's very hedgehog, for better or for worse. And in that sense, it's quite bloodless. Bloodless might leave people unmoved, but if we have to have something, then it would be okay to have this very general category. Now, Jess Eisen on this panel called herself the skunk at the garden party, which was a very delightful moment. But she was questioning, and she called herself that because she was questioning focus on the abstract property personhood status at all. She's saying, look, this is bad because it's flattening out all of the specificity for non-human animals, which is the thing that motivates many people and needs to be attended to. The specific ways, for instance, in which dairy cows suffer. And part of me really agrees with that. And in Canada, we have actually deliberately avoided using property personhood when doing some of the very same work that groups like the Non-Human Rights Project do in terms of trying to get better rights for apes, elephants, and cetaceans. So for instance, the Jane Goodall Act, which will establish, if it's passed, an advocacy process for these animals, follows the Dolphin and Whale Captivity Act, which was passed just a few years ago, not specifying whether the cetaceans are property or persons. So this was deliberately done, even though there's involvement of an Indigenous senator in the passing of the bill who would has spoken publicly about his belief in the personhood of non-human animals and the need to have reconciliation with non-human animals, but it was just thought better to leave it out. I tell my animal law students often now that I think most of us have a paradigmatic animal that we're carrying around with us in our heads. So what do you think when you hear animal or non-human animal? I think for many people, they think of dog or cat. Others think of farm animals like pigs, cows, chickens, fish, now that over half of them are farmed. I think for me, I think wild animal. And why do I do that? Well, because for fish, for wild fish, and also for the fox, Pearson, there's that rule that the case established, the capture rule. And it basically held that an animal isn't property unless until it's captured. That's just what the rule is. And many animals in the wild never are captured. Their habitats are under dire threat, and they're the frontline casualties of climate change, no question. But there are animals, including foxes, that don't ever get caught. And property is actually not really very relevant for them. They're free and they own themselves in the same way as, say, you and I do. And I have written here a kind of tongue-in-cheek a mock dissent for the Pearson decision, which is being published in, like, I think the book is actually like in the mail on the way, which basically builds on this idea that there is a kind of a self-ownership there for the fox in the Pearson case. So property then, as I see it, wouldn't necessarily be a uniformly desolate space where all animals exist, either in an owned or they're going to be shortly owned way, like as I would associate with Gary Francione. This leads me to think, well, perhaps property is not as important as he had always emphasized, and that his book, Animals, Property, and the Law, had led us to believe. And so quasi is a sense that, well, we should capitalize on then to some extent that space and that sense that is there for some animals, and think about how to expand or include it for more animals, more species. Okay, I don't want to make it sound as if I'm trying to reconcile things, because I'm not supposed to be doing that. The whole fox hedgehog theme for this talk is I'm trying to put that forward. But quasi really is meant to be a framework, and it's really meant to be a proposal that might land or sound or stick, or it might not. I don't really know. And I think such a thing is difficult, if not impossible, to predict. And here's where my own theory of history kicks in, insofar as I think things are fundamentally wild and unpredictable, especially ideas. Why they're taken up and why they're not taken up, why they get forgotten about and then revived again in a different way. This is happening all the time, and it is very unpredictable. So for instance, Berlin and the Greek metaphor, which is, goes from being a story about basically sexual harassment of the hedgehog to Tolstoy on historical skepticism. I mean, how does that happen? And who could have predicted that could happen? So I do think that there's a fundamental unpredictability here. But there is also a momentum, it seems to me. At least some animals are not mere property due to their sentience and their legally recognized sentience, and they have a weak set of rights, which makes them legal persons of a certain kind. So if you put those two things together, that's something that could move in a positive direction. This way of seeing things immediately problematizes property versus person or rights versus welfare. And frankly, I think that's a good thing. I think that has been stymieing and handcuffing people in a way that is not very helpful and is not very productive. Taking things we already acknowledge are true, seeing them in a slightly different way, not necessarily a radically different way, but a slightly different way, can give us that shift in perspective that can open up other possibilities, the extent and nature of which I think it would be difficult to predict. Thanks so much.
Thank you for your talk. That was great. And we have plenty of time for questions now. So I'm going to read questions based on the degree to which they have been upvoted. So everybody, if you have not looked at the Q&A tab, you still have plenty of time to enter questions in the Q&A tab. And you also have time to upvote the questions that you most want to have addressed in the remaining time that we have. So with that in mind, I can start with the top question, which is how, and you addressed this to some degree a little bit later in your talk, but maybe you can elaborate on it a little bit. How would this idea apply to larger entities or perhaps collective entities such as forests or seas?
Yes, yes, yeah, thanks for that. And you know, I probably didn't say quite as much about this as I could have or I should have. Yeah, I really see it as compatible with that, and that's a good thing. You know, one of the other kind of proposals that's out there in terms of like as sort of another way of describing the property status of non-human animals, there's a kind of like a bunch of them. One is sentient property, companion animal property. There's another one, inimitable property. There's a lot of them. David Faber has an idea he calls living property, which he's been writing about for quite some time. And I originally quite like living property, but one of the reasons why I thought I needed to propose something different and was that because I thought that was a little too specific and too literal and would exclude other entities that are not living in the same way. So for trees and plants, we could say, okay, yeah, they're living, but rivers and lakes living, you know, I mean, we've talked about dead oceans and dead lakes and so on, but it just seems to me that living might be make it a little bit too narrow. And so I think it's very important for environmental entities to be able to be included in this.
Interesting. I could imagine somebody making the same observation, but then going in the opposite direction, thinking that living property is actually too broad because it can include sentient living beings as well as non-sentient living beings. And then there should be a special legal category specifically for sentient living beings. But you seem to think that it makes more sense, is more important to go in the opposite direction and actually have a more expansive category that can include sentient living beings, non-sentient living beings, and non-living beings like forests and seas and then other artifacts and so on. Is that right? And if so, why do you think the more expansive as opposed to actually the more narrow way of precisifying the category is best?
Yeah, well, I think wider is better, just because it might be that if, you know, people are starting to feel ready to do the protections with rights of nature and using some form of personhood to do that, I think that is great. And so I wouldn't want there to be the concept to be out there floating around kind of, you know, working at cross purposes with that.
Interesting, thank you. Okay, great. So next question is a comment followed by a question. The risk is that animals will be relegated to a kind of second-class personhood through the quasi idea. And how can animals be represented in their plenitude on your paradigm?
Yeah, that's a great question. Yeah, the risk. Yeah, no, absolutely. This is definitely an issue. Although I do try to say in the paper, you know, quasi is not necessarily not as good. So, for instance, if you were a quasi-judicial officer on an administrative tribunal, you don't think of yourself as like a judge that's not as good. You're not a not as good judge. You're just it's just a different role that you're being given. And so it's not necessarily to say it's lesser than. And the plenitude aspect of the question, which I also think is very important, is really to say, yeah, it's not meant to capture that plenitude. It's really just a, you know, agnosticism with respect to that, which I know is not something people are going to like or going to be like, oh, this is what I want to take home, you know, put in the bank and keep forever. But it's not meant to be take home, keep, put in the bank, keep forever. It's meant to be more of a transition kind of an idea, which will get us somewhere, which kind of captures in a way where we kind of already are, except for a more explicit language, and leaves us room to move forward some more, but at the same time is not going to be able to do justice to all the different species and all the different animals and all of that. It's really not. And in that sense, of the kind of proposals is very legal in that sense of being just very, like a very empty vessel. And I said at one point bloodless, which is kind of a pun that is maybe not very appropriate, but it is meant to be in that sense, sort of like not necessarily any particular animal, and certainly not to try to capture it. In fact, it's meant to cue or connote the opposite, that this isn't an attempt to capture that. It's more an attempt to put out there a mode or way of thinking that could be used in lots of different situations and scenarios. Hence, to connect to the earlier question, why I think I would go in the expansive direction and not the restrictive direction.
Got it, right. So this is meant to be a transition to perhaps something else, although even this is not necessarily lesser than, even if some people might perceive it as lesser than or worse than personhood or other types of legal status like DECAs, for example. But you do imagine that it could lead to one of these other types of status, and I imagine are staying open-minded about what type of further status it would lead to, be it personhood or some other alternative. Is that right? Okay. And then, so what would you say in response to someone who is worried that introducing or making explicit this middle ground quasi category would actually slow momentum rather than speed up momentum towards this further destination? It seems very similar to me to debates about abolition versus regulation of all sorts of harmful industries, where on one hand, you might think that reforms or regulations build momentum towards more radical changes because they show that we care about this issue and bring us one step closer and so on. But then other people will usually argue, no, they actually slow us down or take us further away because they humane wash the status quo and they lead people to believe that this middle ground is good enough. And so they take capital that we could otherwise be investing in the more radical destination, and they get us to spend this capital on the sort of middle ground wishy-washy thing, and then we end up being stuck there. And so that is, of course, a debate that gets like replicated over and over again in all sorts of specific contexts. But I can imagine it being replicated in this context too, and somebody making that argument against the quasi status, that we could end up being stuck here and feel less motivation to go farther to personhood than we would feel if we really thought that the person thing binary were our only options. What would you say in response to that? Pragmatic,
yeah, absolutely. Yeah, no, and I think there are people who would have that instinct and have that kind of reaction. I would say that there's sort of the irreconcilability about it in terms of the debate that's really like the welfare rights debate. In a way, this is not going to solve that. That's still going to be there. And but I do think that one thing that is good about saying, well, okay, here's this middle ground that is kind of gathering together at least the positive developments, is that it is, it's intentionally kind of saying, okay, it is provisional. It is, and because it's quasi both, it's supposed to sort of prevent you from, from like kind of falling into a sort of a, quietism or something about it. Like, it's weird, right? It's a weird. So if you read, like, I don't know how people felt like when they saw the talk and the advertisement to the talk, but, maybe you had that reaction of, oh, what's this? And I think it would probably retain that, I think. And so then it's an opening to the conversation. It's an opening to this discussion, really intentionally trying to like not get bogged down in that. Because it doesn't really go anywhere. I mean, people just really have very strong beliefs about this, and they have, entrenched positions. But I think that, there is also, in addition to the practical point, there is also this kind of, point about like accuracy or whatever, which is that, it isn't actually correct to say that there are only two options. So when people say that there are, that has got to only be strategic, because it's actually not true. So then we kind of go, okay, well, what is true? That there are these in between. That doesn't necessarily mean you want to go to the in between, but I think that, and knowing that that exists for situations or contexts in which it's just not going to happen, that people are going to go to the full concept. Better to have that than, no, sorry, you're stuck in property, you're in pure property.
Okay,
which is sometimes the reaction that you see, at least judges do. Legislatures won't put it forward until they're more ready to talk about it, or maybe not talk about it, as the Canadian example. But for judges will often kind of default to that, I think.
Great, thank you. Yeah, I might follow up on this a little bit more if we have time, but I want to get to some other questions first to make sure we can get through as many as possible. So the next question is what would the quasi status make non-human animals bearers of any specific duties or obligations? And if so, which ones?
Yeah, interesting. Yeah, I feel like, ever since that damn Lavery decision, and sorry, I don't curse on them on the webinar, but that, I mean, now this is the problem in when people are talking about animal rights now, everybody asks this question, what about the duties? Did we do that before Lavery? I don't know. I never saw that happening. And so that's a very unfortunate consequence of that case. But yeah, no, I wouldn't necessarily go, I don't think it's very productive to go down the road of, well, rights have to have these tight corresponding duties, because I don't think they really do. But again, I'm not a philosopher, so people who are more versed in that might be able to give a better response.
Well, as a philosopher, I can say that I agree with you about that. I think that is the right response. But obviously, these questions play out differently in philosophy and in the law. So it helps to hear that answer from both philosophers and legal scholars. Okay, great. So the next comment is in Colombia, they are already in a quasi place that allows their exploitation. Civil code says that they are things plus sentience. And I think this is in general a concern that people have about all kinds of middle ground categories. Like, as you know, there are already jurisdictions that call animals sentient beings, for example, or they have other designations that fall short of personhood, but seem to be more than thing, and call animals that thing, like a sentient being, for example. But then basically maintain all of their same forms of exploitation and extermination and neglect of non-human populations. And that might make one worry that this is a sort of like empty symbolic gesture that does not have any legal significance or practical significance. And so how would you respond to that concern?
Yes, what I would say here is really come back to this kind of wild unpredictability point. Because it's interesting, something like those not things provisions. So I don't know the Colombia example, but I know Quebec has it now has had it for a few years. Lots of other jurisdictions have that as well. Quebec copied France in that, and so there's lots of countries who've done that. And is that purely symbolic? Well, it's interesting. You might say in Spain, for instance, that they have, or I think it was referendum. They had a referendum which passed it, but I'm not sure it's actually been enacted yet. But you might say, well, okay, it's purely symbolic. But at the same time, you'll get a decision. For instance, there was a Spanish decision just, I think, a week or two ago, which talked about a separation divorce case. And they talked about the dog is not just property. And so there has to be sharing for the best interest of the dog and going back and forth and this kind of thing. And I feel like, well, you could say that would have happened in Spain even without that legislative provision, but I think it's extremely unlikely that the judge in that case would not have known about that legislative provision, because it would have been a big deal, And so I think you don't really know when something that's symbolic is purely symbolic, or what kind of influence it's going to have. Austria and Switzerland, they have been recognizing animal dignity, I think, since like the 1970s, or like in the Constitution. And often, when you hear animal lawyers talk from those jurisdictions, they'll say, what you have to understand about this dignity recognition is that it really doesn't result in animals being treated any differently here than anywhere else. Everybody eats animals, they use animals, it's not any difference. But it's so interesting because in the case that Kristen Stolt talks about, the wild parrot case, there it was the Austria and Switzerland dignity provisions that are being pulled in. So who could have predicted that? If you were in Switzerland in 1970 and you were talking about putting that in the Constitution, would you have thought that in 2021 there would be a case in Brazil about a wild parrot that would end up, this is the type of stuff we're talking about. This is like, nobody knows this stuff. Nobody knows how this can happen, how this can work. So when people say things are purely symbolic or meaningful, I think, we sometimes say that to ourselves because we're trying to console ourselves in the sense of like thinking, oh, this is not really a very big win. This is, just kind of keep our expectations low type of psychological thing. But I do think that many times these kinds of recognitions, they really have an impact. And the sentience recognition, for instance, like even the fact we only have it in Quebec, we don't have it in the rest of Canada. But, I was listening to a radio interview, it was the executive director of Animal Justice, a friend of mine, Camille Labchuk. She was talking on a radio program, and there was a very back and forth, and she really won the point and won the day. And how did she do it? She said, well, they're sentient. And that was it. The other side didn't have a response to that. The moderator kind of wrapped it up, and it was awesome, and I remember texting her, and I was like, oh my God, Camille, this is totally what is really powerful about this. And so I think we want to be careful, I think, to say about things that don't seem like maybe they're necessarily achieving a lot, that they're merely symbolic, or that I think we actually don't know, and we don't really have any way to calculate that, what kind of impact they're having, let alone what kind of future impact they might have and how they might be drawn out or used in a jurisdiction that's very far away and in a very different context even.
Yeah, thank you for that. I really like that answer. And I think in general, not the questioner in particular, but I think a lot of people can have an expectation that if one of these laws is passed, or if animals are mentioned as persons or sentient beings in a constitutional text, then that should be sufficient to end all kinds of exploitative practices. But it might not be sufficient for that. Even a personhood designation might not be sufficient to that, but it might be necessary, or at least helpful. It can signal that our social values are changing and get more like energy behind activism and advocacy, and more ammunition for activism and advocacy. And then those things together can produce change in the future. But yeah, like legal changes by themselves, absent further social and political and economic changes, might not be enough to make a difference by themselves. And we should probably be prepared for that, no matter what the content of the legal changes. Okay, great. Yeah. So the next question is, would this model suit adversarial as well as inquisitorial systems? And maybe you can also explain what that means for the non-legal experts in the audience.
For sure. Yeah. So the adversarial, inquisitorial, this is the kind of contrast between common law and civil law jurisdictions. So in common law, it's adversarial because in a courtroom, it's always going to be the lawyers coming and giving things to the judge, and then the judge makes a determination. The judge is supposed to be totally passive, versus inquisitorial systems and civil law systems where the judge is more active and can actually go and investigate themselves. They're not just relying on witnesses and experts. So it's sort of like the two kind of models. I tried in the talk to outline how I think that quasi might, for inquisitorial systems or civil lawyers, won't sound as good because, or nice, because they're not going to like a kind of mixed category, because they're very into like purity of categories in civil law, at least in my experience. Whereas common law people are much more magpie eclectic, like they just are, that's just the way people are kind of more reared and trained. And so I think it's more palatable to them. But in terms of actually like operationalizing in a judicial context, for instance, I don't know if that's what the question's asking more of. Like, would it be better in a litigation context in one of the systems than another? I don't really have a view about that. I don't really have this. I have to think about it. I should say probably I would have to think about that a bit more.
Got it. Thank you. I now realize that some questions are jumping around in the Q&A because of upvoting. So I will go back up and catch some questions that I missed the first time around. So one is how, and I hope you know what this stands for. How would you classify IPR issues emanating from animal products, such as medicines and vaccines? Oh, maybe that means intellectual property rights.
Property, yeah. Yeah, interesting. Yeah, that is something, again, I have not given any thought to. So I hesitate to speak.
Fair enough.
But I wouldn't see how IP would make anything particularly special. And in this context, it'd be nice to be able to talk to that person more. Maybe they could email me afterwards or something.
Okay, you heard it. Feel free to email Angela if you want to talk further about that. Okay, great. So yeah, this is another question that I have heard many people have about a sentient being status. And so I wonder what you think about the quasi status. Is it an implication of your proposal that we can or should ascribe quasi personhood to some human beings? Should we make distinctions between different non-human animals so that some are persons, others quasi-persons, and others non-persons? And potentially, should we make similar distinctions within our own species?
I would say no to that. That's just my gut. That's just my gut. It's probably also my kind of feeling of like where I was going through the code and talking about the law of persons. You do natural persons, human beings are in there, all human beings are in there no matter what. And then the more artificial category, yeah, that would be my reaction to that.
And I assume this is coming from a place of pragmatism rather than as a principled application of the view. I imagine that if you were trying to come up with a set of concepts or categories that made sense in principle and then you applied them diligently, then you would run into these types of questions. You would either, for instance, have to include some non-humans as full persons or include some humans as quasi-persons. And it might be difficult to know exactly where, how, on a principled basis to draw that line. But if the goal is really to come up with a pragmatic middle ground category that can capture many non-humans, at least in the short to medium term, as we build momentum towards some sort of more unified conception of legal status, then you might just sort of be comfortable with it not being super clean or principled how the lines are drawn. Is that roughly right?
Yeah, that's definitely right, Jeff. And I would add to that too, you know, if it's part of it is about kind of palatability and making this like sort of easier transition for people, then I think messing with the human category would seem like a mistake, I think.
Yeah, that seems right. Definitely seems like a third rail in this discussion for sure. Okay, great. So why do you not include anti-cruelty laws as among the statutes like pet trusts, et cetera, that are already taking animals out of a strict property classification?
Yeah, that's a great question. And I probably kind of went past that a little too quickly, which is to say that sort of starting idea about rights, animals already having rights, though that is based in animal cruelty statutes and in that history. So the animal cruelty statutes are a very important part of this, actually. And it's interesting because, you know, the person who has made that argument is Cass Sunstein has written about this in a few places, you know, and you know, I'm not sure. I don't know him. I've never had a conversation with him about this, but you know, part of it is, you know, you don't just want to note that and just kind of that would be it. Which maybe is, I don't know, seems to be a little bit maybe what Sunstein's doing. I'm not quite sure, to be honest with you, but for me, I'm using it as a starter, like it's a generator, and it sort of gets the argument going. And it wouldn't at all be, well, you know, they already have rights. Yeah, that's it. It's much more, that is a way of saying they already have a modified form of personhood. And so I would include it on that side, as opposed to the property side, where I'm talking about the pet trusts and the other senses in which non-human animals are already more than mere property. But yeah, I'm glad that whoever asked that, because that's important part of the argument.
Yeah. So just on that point, we previously have discussed forests and seas and plants and other beings that might in various ways count as quasi-persons or having some plus type of legal status. I wonder what you would say about other objects, other things where we might have laws about not damaging them because of their owners or because we have a public interest in them. So like paintings or statues, if we have a law against damaging or destroying a painting or a statue because somebody owns it and cares about it, or because the public in general takes an interest in it, would you call that a right? And would you regard that as sufficient for that thing to have quasi-personhood status? It seems like a stretch to me to say that a painting has a right simply in virtue of the fact that we passed a law against damaging it for the sake of humans who care about it. And so I wonder what you would say about that case, and then how that squares with your approach to the non-human animal case.
Yeah, that's a great question. And in fact, a colleague of mine, just last Friday, I was presenting this paper to our graduate students, at U of T, and my colleague Malcolm Thorborn, who invited me, asked basically a version of this same question with respect to the Mona Lisa. So if you wanted to, damage the Mona Lisa, you would not be permitted to do so because it would be protections, a kind of a public trust idea of the important cultural object. And I haven't given it a whole ton of thought since between now and Friday, as you're going to be able to tell from my answer. But I will say though that my instinct is more to agree with what Jeff is saying, which is that while these things are important and there are legislative ways of recognizing that and protecting that, to me it doesn't feel like it's the same or historic building, for example, is another example that you could think of. That's different than the quasi-hood. And I do think that it would be important for the concept to have some parameters. And actually, I think maybe like the painting, the historic building, those might be good examples and good ways of trying to just kind of craft a little bit like what are the limits, like what are the parameters to it.
Yeah, so then I do wonder a little bit what else is present in the quasi case that is absent in that case, because it sounds an awful lot like quasi personhood is what happens when there are various types of laws that protect an entity for some reason or another that fall short of the types of rights that we associate with legal personhood and the kind of intrinsic status that comes along with legal personhood. And so if the type of protection that a painting receives when we decide not to damage or destroy it for the sake of humans who care about it is not enough for quasi-personhood, then I really wonder, okay, so what else is present for the animals and the forests and the seas? What do they have that the painting lacks? What do the anti-cruelty laws have? Because structurally those are the same. This is a law against damaging or destroying what is technically an object under the law for the sake of human owners or human communities who care about it. It seems relevantly similar. And I think this is where the personhood, like non-human rights project people are coming from when they say anti-cruelty laws are all well and good, but if what they amount to at the end of the day is just, this is a law against damaging a particular thing that we happen to care about, but we could repeal it once we decide to stop caring about this particular thing, then that is not really going to cut it in terms of like establishing what we would take to be a right.
Yeah, no, I think that's a good way of thinking about it. And so, just to kind of try to follow this a little bit, I mean, I think it has to have something to do with intrinsic value. With intrinsic value that is not dependent on humans recognizing it or deciding, okay, this building is important enough, or this painting is a very, very special one, and so we'll do that with it. Because I think for non-human animals and also for other, I think, important rivers and so on, especially if it's within an indigenous perspective, it's because the animals or because the environmental entities are themselves so important, separate and different from anything that we could ascribe. It doesn't depend on our recognition. I would think that maybe that would be the type of line of inquiry to follow, but yeah.
Great, thank you. Okay, good. So we have at least a couple more questions in the chat. Others, feel free. We might have time for one or two more as well. So feel free to add if you have any follow-ups or any other questions. So one further comment is First Nations in South America, among other places, won't become vegan. They have other feelings and ideas about animals. We cannot impose a Eurocentric or North American ideal onto these communities. There are already imposed nation states, ideas about development, and so on. And so I guess to put it in terms of a question, how do you think about, in general, this idea of imposing a particular conception of who matters and who does not matter on populations that might disagree with those views about intrinsic status?
Yeah, no, I think this is a super important question. It's very interesting because this comes up a lot. Conflicts between animal rights advocates and indigenous communities. I mean, here I would really defer to indigenous people themselves, who many of whom do see their views as consistent with veganism. In fact, they think, animals produced in a factory farm environment, whether it's fish or whether it's other animals, that is, a violation of the respect and the relationship with animals. And so they see their veganism as really being the only way that they can keep intact or keep the integrity to their relationship with non-human animals. So I do think that it needs to be recognized, and that's something that is a point of contact and a point of positive, to develop and build on. But yes, obviously there is an issue of how do you come at it in terms of respectfulness and so on. And so you would have to be careful, just the way you would be, I think, you need to be about any kind of concept that you came in with from your global north kind of perspective, or your settler perspective, as we'd say it in Canada.
Great, thank you. And we have a comment too, which is in addition to the examples that you mentioned, that Germany recently updated their constitution to include the fact that animals are sentient beings. So that is, I guess I didn't know that actually. That's interesting. Another example, Mexico City is another recent example as well. In 2018, their constitution came into effect and includes language about animals as sentient beings. So good. I do have time to follow up on this earlier exchange, and again, others feel free to put more questions in the chat if you want. We have about 10 minutes left, so time for one or two more questions. So in an earlier exchange, you noted that if people are going to insist on the person property distinction, or the person thing distinction, however you characterize the distinction, as a binary, they must be doing that for strategic reasons, because as a matter of fact, there are actually many different categories, including some categories in between those two extremes. And I wanted to follow up on that because I know, at least the way the Non-Human Rights Project and other proponents of the person thing binary, the way they describe the concepts, they genuinely do see it as a matter of principle, as a binary, mutually exclusive set of categories. And so this really is principled in addition to being pragmatic for them. And I think that the way that they understand it is that to be a person is simply to be the type of being that has the capacity for rights. You are the type of being that can have any rights at all. And then what rights you have are going to be a matter of what your interests and needs and vulnerabilities are. And that can vary widely from person to person, depending on what their interests and needs and vulnerabilities are. But what makes them all persons is simply that they are the types of beings who can have rights at all. And then to be a thing is simply to not be the kind of being that can have any rights at all. And when you think about it that way, it does make sense analytically, conceptually, that it would be two mutually exclusive categories, and it would be hard to imagine there being a third category between them, because one can either have rights or cannot have rights. And if you can have any rights at all, then you count as a person. And if you cannot have any rights at all, then you count as a thing. And then within the category of persons, we can make further distinctions based on what type of person you are and what types of rights you can have. And I guess I just wonder, so that is my understanding of how they approach these concepts. And so I guess I would ask, as one question, do you understand or define those categories differently in a way that does create conceptual space in the middle for a genuinely distinct category? And if not, then how would you respond to their way of defining it? How would you make sense of your original claim that this must only be a pragmatic view rather than a principled view, if that is the way that you are both understanding that distinction?
Yeah. Well, I guess what the problem is if it is being looked at this way, that person just is something that can have rights, then non-human animals are already persons. So then the whole project of trying to get them personhood by getting the habeas corpus claim recognized it doesn't have it. That doesn't make sense. They already have it, right? So it has to be something more than that. And then also just looking historically at things. because we just know that there are these categories of entities, who are falling in between, then it can't just be two categories. So I feel like when I hear them speaking about it, they repeat it a lot, and I feel like it's supposed to be, persuading you by virtue of the repetition or the force or something. I don't know, but it isn't. To me, the reason why I said I think it has to be pragmatic or strategic is because to me that's the only way that it kind of makes sense. Because I think if you're thinking about it in a principled sense, it's hard to see really, because they are already persons then, and so the whole purpose and the whole motive for it would be difficult to discern.
Yeah, interesting. Thank you. Yeah, I guess I can imagine them offering two possible responses to that. One would be to hold the line and to simply deny that the protections that currently exist amount to genuine rights. Maybe they would use the painting analogy and say, really, all this is a law preventing damage to an object that people happen to own or care about, but that falls short of being a right because of the limits on how it can be advocated for, and how the animal can be protected. So one thing they might say is, no, they don't in fact yet have personhood or are not yet recognized as persons because these protections fall short of being rights. Then I guess the other reply they could make would be, well, yeah, I agree. They already are persons. And what we are trying to do is get the courts to formally recognize that, to put it in writing, that they already have been persons, and we are finally acknowledging that. I'm not sure what reply they would offer, but I imagine those would be the two main options. But in any case, I hear you. I take your reply, and I think that makes a lot of sense. We do now have one additional question in the chat with about 5 minutes left. So what would appeal to anthropocentric, system-trained humans to accept inherent dignity and rights of animals? How can we get through to self-interested speciesist humans who hold a monopoly on coercive power and get us to expand our moral and legal and political circle to include very many more non-humans than there are humans?
Yeah, I mean, I don't have the answer to that, although I do think that, the current ecological crisis, I mean, that actually, that plays right into our self-interest and our need to preserve ourselves and all of our things and all of our comfortable whatever, right? And so in that sense, that is one way to sort of bust through. And if it can bust through for environmental entities, then perhaps it can for non-human animals, in the sense that Kristen Silt's talking about, that they kind of get swept up in it, or just that in the sense of just kind of opening people's minds to the idea that there are these entities that have intrinsic value for themselves. And so that needs to be legally recognized. David Boyd's book, The Rights of Nature, it's subtitled The Legal Revolution That Could Change the World. And he published it I think about 2017, so a few years ago now, but it's very prescient actually in terms of kind of mapping out a way to sort of move forward. And animal rights people often don't like this convergent interest sort of idea, things shouldn't be done because they're also good for us. But the reality of it is probably that is when we're going to, at least in enough numbers of us, turn to looking to solutions, that is going to probably have to be engaged. And it is, right? Obviously, it's not good that it is, but it is. And so in that sense, there is some hope there.
Great. Yeah, good. So we have time for one final question, which there now is an additional one in the chat, and then we can wrap up. And actually, this looks like a follow-up on the conversation you and I were just having about the binary between persons and things. So some people think personhood is the capacity for fundamental legal rights rather than simple legal rights. So quasi could be a way of recognizing animals as possessing maybe simple legal rights, but not fundamental legal rights. And so I think this is offered as a way of making sense of the distinction between persons, then quasi-persons, and then things, where things would lack any legal rights, quasi-persons would have simple but not fundamental legal rights, and then full-on persons would have both simple and fundamental legal rights. How would you feel about that way of mapping the terrain?
Yeah, I mean, the thing is, what I like about the simple rights, Saskia Stuckey's idea, and the it gets things off the ground, but I don't think you want that to be, the whole point for quasi is to be able to be more capacious. So it has to also be able to include fundamental rights. I think that's kind of a like a no bargaining kind of thing. But it might be that as a matter of analytically, as a description right now, yeah, something like that kind of position would be good.
Got it. Yeah. There, I think Steve Wise and so on will just say at that point this is just personhood, like straight up personhood. But maybe then we have the strategic argument about what we should be calling this in the short term if we want to be making inroads with actual like institutional actors. In any case, okay, that is all we have time for today. So let me first of all thank everybody for being here and participating in this great discussion, and then to thank you again, Angela, for being here to give this talk. It was a really fantastic talk, and I love the discussion. So yeah, thank you again. And I'll just say, but before I give you a chance to sign off too, thanks again to Becca, my co-host. And Mari, who organized and arranged this talk behind the scenes, and of course to the Brooks Institute for Animal Rights, Law and Policy for supporting this talk as well as the other talks in this series. And everybody tune in. We will have more of these talks in the spring semester, so we can all look forward to that. But yes, Angela, I'll let you have the last word, and thank you again.
Okay, that's awesome, Jeff. Thank you for having me, and thanks to the team and to Brooks and to all of the people in the audience for their great questions. It was a really, really good discussion. It's given me a lot to think about.
Okay, great. Have a good rest of your afternoon, everybody.